like to welcome all of you to the, I'll call it the fourth, I'd like to say annual, but COVID and other things sort of interrupted. So it's the fourth Wallace lecture. We started the Wallace Endowed Lecture Series a number of years ago in honor of Judge Wallace, who's sitting here on the third row. Judge Wallace, I clerked for him many years ago, 1984 to 85. He was then a mere judge on the Ninth Circuit. He eventually became chief judge and now is senior judge on the Ninth Circuit. I think he's in better physical condition than I am today. He is an amazing person who stays physically fit and mentally fit and just does a great job and is really an example for all of us. He made a real impact on me, on my career in law, and I'm grateful. And so a number of his former law clerks and I set up this series. We've also set a parallel Wallace lecture series at BYU. The idea was that it was nice to take what would probably be perceived publicly as ideological opposites and have them talk to each other through the Wallace lectures. And so the idea of the Wallace lectures is that there's sort of a cooperation speaking between people at BYU Law School and UC Berkeley Law. Judge Wallace, as many of you may or may not know, was on the short list several times to be a justice on the Supreme Court. There are those of us who wish he had been appointed to the Supreme Court. He would have been an excellent Supreme Court justice, but he's also made an amazing mark around the world, educating, frankly, Supreme Courts all over the world on judicial administration. And I believe there's actually a building in your honor in another country. I can't remember which country it is. Can you remind me? There's a Judge Wallace, I know there's a Judge Clifford, J. Clifford Wallace building in a country, but in any event. And we're very fortunate this year that the person delivering the Wallace lecture is Dean Chemerinsky, who is a preeminent scholar in all kinds of things, but especially First Amendment law. And the Wallace lecture series are supposed to focus on three of Judge Wallace's passions, namely the rule of law, the religious freedom, and judicial administration. And I'm really happy to have the Dean Chemerinsky agreed to speak this year on the particular subject. I'm looking forward to it very much. And the Dean has been the Dean of Berkeley. I probably don't need to, everybody knows him here, but in any event, he's an amazing scholar with a national reputation and has for many, many, many years. Professor Groh, who's sitting next to him, is a professor at BYU Law School. She has a distinction that is almost mind-boggling. She graduated from Harvard Law School summa cum laude. I think the first person to graduate summa cum laude at Harvard Law School at the time she did it, 15 years had passed. I remember working at a law firm years ago where someone was debating whether he or somebody else had the highest grades in Harvard Law School history, and I was actually really impressed. But I'm looking at this, I'm pretty sure that Lisa had higher grades than either of those two people were arguing about who was the smartest between the two. So in any event, we have a really excellent pair of people here. Dean Chemerinsky will be talking on the subject chill, so about how the Supreme Court protects against or fails to protect the chilling of free speech. And then Professor Groh will comment, and then there'll be a question and answer period afterwards where we'll have the chance to ask both of them some clarifying questions. So, thank you.
Thank you. Thank you so much for the kind introduction. Thank you for inviting me to the lecture. I also want to say a little bit about Judge Wallace and a little bit about Lisa Groh's son. What wasn't mentioned was that Judge Wallace graduated from Berkeley Law in 1952. He came to Berkeley after a distinguished career in the United States Navy. He was appointed to the United States District Court of Southern California in 1970 by President Richard Nixon, and then elevated to the Ninth Circuit in 1972. If that doesn't make him the longest serving living Court of Appeals judge, it has to be close to that. And it has to be among the longest serving Court of Appeal judges ever in American history. He has such a distinguished record as a judge on the Ninth Circuit His opinions set precedents in so many areas of law. And all I can say, Judge, is that I hope we all can be like you in our career, love work the way you do, and follow your example and model. So please join me in a round of applause for Judge Wallace from his lecture. And I want to thank Lisa for coming and being a commentator today. And I hope very much we can follow the pattern and we can do this next year at BYU. Maybe I can be the commentator on your panel in favor there. In addition to graduating from Harvard Law School, she clerked on the United States Court of Appeals for the Circuit for Judge Michael Ludig, clerked on the United States Supreme Court for Justice Anthony Kennedy, and she's been a professor at BYU for 18 years. In addition to teaching constitutional law, she's also one of the leading experts in the country with regard to disaster law. And having lived in California most of the last 40 years, I cannot imagine any field of law more important than disaster law. Over the weekend, I was reading a complaint that was filed by the Harvard faculty against the Trump administration. And a core part of the complaint was that the actions of the Trump administration were chilling the speech of the faculty in a manner that violated the First Amendment. I teach both federal courts and First Amendment law, so it naturally caused me to wonder, do they have standing to be able to bring such a claim? Is such a claim ripe for review at this point? And is there a First Amendment violation in the actions of the Trump administration in chilling speech? Chill is a concept that's ubiquitous throughout the First Amendment. Lawyers constantly raise chill in their briefs, and judges frequently will talk about chill in their opinions. Yet the Supreme Court has been very inconsistent in defining what's required in order for a claim of chill to be justiciable. When is there standing? When is it ripe? And the Supreme Court's been very inconsistent with regard to when is a claim of chill sufficient to state a First Amendment violation. Based on this inconsistency, having taught these cases for so many years, decided I want to write an article about it. And I turned to my very favorite co-authors, my son Alex. We actually started with a conversation where we had the title, Chill, before we had the rest of the article. And then, over many months, we wrote the article that I'm going to talk about today that's being published in the Texas Law Review. In the article, we develop it in 4 points. I'm going to speak of 3 of them today to leave plenty of time for Lisa and then for your questions. First, I want to talk about how the concept of chill is pervasive throughout the First Amendment, and the Supreme Court has been inconsistent, both as to justiciability and as to constitutionality. Second, I want to make the normative claim that chill should be very important within a First Amendment analysis. And then third, and maybe most important, I want to present our proposal for how courts should deal with issues of chill, again, both with regard to standing and rightness and with regard to the merits. As to the first point, that the Supreme Court has been inconsistent, albeit recognizing the pervasiveness of chill, let me start by talking about it from the perspective of justiciability and then from the perspective of First Amendment merits. As you know, in order for a federal court to hear a case, an individual has to have standing. It requires that the person be injured or imminently likely to be injured, that the injury was caused by the defendant, that a favorable federal court decision be likely to remedy the injury. Rightness is another requirement under Article 3 of the Constitution. The Supreme Court has said that in order for an individual to show rightness, there has to be a significant hardship to not having pre-enforcement review, and the issues have to be properly focused so as to facilitate judicial review. It's striking when I teach federal courts how inconsistent the cases are with regard to claims of chill and justiciability. Let me give a couple of examples of cases where the Supreme Court has rejected chill as being insufficient. One is a case from 1971, Laird versus Tatum. The complaint alleged that the United States Army was routinely spying on civilian groups that were engaged in anti-Vietnam War protests. The argument was that this monitoring by the Army of protest was chilling expression. Nonetheless, the Supreme Court dismissed the case for lack of standing. The Supreme Court said that a claim of chill by itself is insufficient to meet the requirements for Article 3. The Supreme Court followed this up just a decade ago in Clapper versus Amnesty International. This involved a federal statute that allowed the National Security Agency to intercept communications between those in the United States and foreign countries. Lawyers brought a challenge to this. They said that they routinely represent clients in these countries. They are required by the law of professional responsibility to keep client communications confidential. They believed they couldn't do so if they were going to use electronic means. Therefore, the only way they could ever go to speak with their clients would be to actually travel to the foreign countries. In other words, they claimed that their communication was chilled. The complaint also had as plaintiffs journalists who said that they regularly wanted to speak to sources in these countries, but they couldn't do so because their communications were chilled by fear of being intercepted. The complaint included business people who made a similar allegation. The United States Supreme Court, in a 5-4 decision, dismissed the case on standing grounds. The Supreme Court said none of the plaintiffs could show that their communications had been intercepted by the National Security Agency or were likely to be intercepted by the National Security Agency. After all, the NSA doesn't tell people when they're intercepting communications. The Supreme Court said that the claim of chill was insufficient to meet the standing requirements of Article 3. Justice Alito, writing for the court, cited to Laird versus Tatum, saying a claim of chill is not sufficient for standing. But in other cases, the Supreme Court has found that chill is sufficient for standing. Sometimes the court has done so explicitly, sometimes the court has done so implicitly. As an example of the former, there's the case of Meese versus Keene, a case I want to come back and talk about in a bit. What's involved here was the federal law allowed the Attorney General to designate certain films from foreign country as propaganda. This involved some films from Canada that involved the issue of climate change. And under the federal law, in order to show these films in the United States, they literally had to be labeled as propaganda. The claim that was brought against this was that it would chill speech. People might not be willing to show films in the United States if they have to be labeled as propaganda. Also, this would be impermissible compelled speech. The government would allow the movies to be shown only if they had a label required by the government. The Supreme Court found that the claim of chill was sufficient for standing for Article 3 purposes. As I'll talk about, the court then went on and said there was no First Amendment violation. But what's the difference between the claim of chill, say, in Laird versus Tatum and Clapper versus Amnesty International on the one hand, as opposed to the claim of chill in Meese versus Keene? Why in the first two cases was it inadequate? In the latter case it was sufficient? The Supreme Court didn't explain. Or take a more recent case from just a few years ago, American Prosperity versus Banta. Not-for-profit organizations have to file with the federal government a list of who their donors are. And the reason is it helps the administration of tax law. When we file our taxes, and by the way, they're due tomorrow, we're allowed to claim as a deduction money that we give for not-for-profits. But the one way that the federal government can make sure that people actually gave the money to not-for-profits is for the not-for-profits to list who they got money from and to double check. California adopted a law that said that not-for-profits operating in California would have to file with the Attorney General the exact same form they were filing with the United States government. Nothing additional was required, and California said these forms would be kept confidential. Americans for Prosperity, a group founded by the Koch brothers, brought a challenge to this. And the Supreme Court, in a 6-3 decision, found it violated the First Amendment. Chief Justice Roberts wrote for the court and said that forcing them to file this form with the state would chill their speech and chill their association. But again, why in this instance was the claim of chill sufficient, whereas in the instances of Laird versus Tatum or Clapper versus Amnesty International, it's insufficient? Intuitively, I think the Koch brothers are much less likely to be chilled than those protesting the Vietnam War or those worried about communications with foreign countries being intercepted. Yet the Supreme Court didn't even think the issue of chill and standing was important enough to discuss Article 3 of the Constitution. The Supreme Court just said there was a First Amendment violation. I think there is a conceptual reason why it's so difficult to apply the law of Article 3 with regard to chill. It's the very nature of claims of chill that it's about something that didn't happen. And how can you ever measure something that didn't happen? So it's very easy for a court, when it wants to dismiss a consideration of chill, to say, oh, it's just too speculative. Whereas if they want to accept the claim of chill as sufficient for standing, they allow it. Just as the court has been inconsistent with regard to chill in Article 3, so has likewise been inconsistent with regard to claims of the First Amendment and the merits. One of the things that was interesting in writing this paper was trying to identify the different ways that the Supreme Court deals with claims of chill under the First Amendment. And I would identify three. One is doctrines that have been developed specifically out of concern for chill. The most important of these is the overbreadth doctrine. The overbreadth doctrine says that when a law is substantially overbroad in the speech that it regulates, a person to whom the law constitutionally may be applied can argue that it's unconstitutional is applied to others. To make this less abstract, let me give you an example. A city adopted an ordinance prohibiting all live entertainment. A new dancing club brought a challenge to that. The Supreme Court said, even assuming that nude dancing can be constitutionally prohibited, nonetheless, this entity could bring a challenge saying the law is unconstitutional as applied to others. The unconstitutional sense that prohibit all live entertainment, prohibit all concerts, all plays, all athletic events. So the usual rule is that a person can only raise claims that he or she has been personally injured. Overbreadth allows somebody who can constitutionally be punished to be able to argue that it's unconstitutional for the law to be on the books because it might be applied to others. Overbreadth exists only in the context of the First Amendment. There's no overbreadth doctrine under due process. There's no overbreadth doctrine under equal protection. There's no overbreadth doctrine under the Fourth Amendment. Why is there overbreadth under the First Amendment? The court is concerned that so long as the unconstitutional law remains on the books, it will chill people from engaging in speech that's constitutionally protected. The court is concerned that it's so difficult and so expensive to bring challenges that people will simply refrain from constitutionally protected speech rather than bring the challenge. In other words, overbreadth is a doctrine that's created entirely out of concern with chill. There's a related doctrine, vagueness, that also in part is motivated by concern of chill. The law is that a government regulation or statute is unconstitutionally vague if a reasonable person can't tell what speech is allowed and what's prohibited. Vagueness is not limited to the First Amendment. Any law can be challenged as vague under the Due Process Clause. But the Supreme Court has said that vagueness applies with special force under the First Amendment. And the Supreme Court has explained that's because it's worried that when there's a vague law in the books, when people can't know what speech is prohibited and what's allowed, they'll likely be chilled from engaging their expression. There's a second way in which vagueness comes up in the First Amendment, and that's the Supreme Court finding government actions to be unconstitutional because of their chilling effect on speech. It's not that there's a whole doctrine, like I was just talking about. Rather, the court in a particular instance will say, there is a sufficient likelihood that the government action will chill speech that it violates the First Amendment. The most prominent example of this, but certainly not the only example, is with regard to disclosure requirements. I already mentioned to you the example of Americans' Prosperity versus Bonta, where the Supreme Court found that the disclosure requirement was unconstitutional because of chilling effect on speech. But there are many Supreme Court cases that have found government disclosure requirements to violate the First Amendment because they'll chill expression. One of the first and most important cases was NAACP versus Alabama in 1958. Alabama required organizations in the state to disclose their membership lists. the National Association of Colored People brought a challenge for this, arguing that the disclosure requirement in the context of Alabama in the 1950s would chill people from joining the organization. The Supreme Court agreed and declared the Alabama law unconstitutional. Soon after, there was a case, Shelton versus Tucker. Louisiana adopted a law that required that school teachers who work in public schools disclose all of the organizations they were a part of. The Supreme Court applied NAACP versus Alabama, and the Supreme Court said, in the context of Louisiana in the 1960s, this requirement would chill teachers from joining certain organizations, especially civil rights organizations, and declared it unconstitutional. I could go on in a long list of cases where the Supreme Court found that the risk of disclosure with regard to chill was great enough to violate the First Amendment. In fact, the Supreme Court has said there is a First Amendment right to speak anonymously. McIntyre versus Ohio Election Commission was a key case here. Ohio had a law prohibiting the distribution of anonymous literature with regard to elections. A woman distributed an anonymous leaflet with regard to a school board election. She was convicted under the statute. The Supreme Court overturned her conviction, and the Supreme Court talked about the long history of people writing under pseudonyms. The court said that there is a First Amendment right to speak anonymously. Why? Because there's instances where disclosing one's identity will chill expression from occurring. And yet here too, the Supreme Court has been very inconsistent as to when it's willing to allow claims of chill to be sufficient for a First Amendment violation. I mentioned to you Meese versus Keene, the case that required that the films be labeled as propaganda. Interestingly, the court there found that the claim of chill was a sufficient injury for standing, but the Supreme Court rejected the First Amendment claim and upheld the government's requirement. Or another case from a different part of First Amendment law, Brandsburg versus Hayes from 1973. The issue in this case was where reporters had a First Amendment right to keep their sources confidential. The claim was that if reporters had to disclose their sources, it would keep them from being willing to speak to reporters, that confidentiality was essential in many instances for communication. We can think of major scandals that were uncovered only because there were confidential sources willing to talk to reporters. The most famous, of course, was the work of Woodward and Bernstein in uncovering the Watergate cover-up, thanks to a source that they then called Deep Throat. It likely would not have come forward but from the ability of Woodward and Bernstein to promise confidentiality. However, in Brandsburg versus Hayes, the Supreme Court, in a 5-4 decision, claimed and held that there's no First Amendment right of reporters to keep their sources confidential with a subpoena before a grand jury. Justice Byron White went before the court and said, there isn't sufficient proof that sources will not come forward without promises of confidentiality. The court expressly rejected the claim of chill. And so you see, what's the difference between the instances where the court finds that chill violates the First Amendment and where it doesn't? It's just the inconsistency I mentioned. There is a third way in which I think chill comes up in the First Amendment, and that's the way concern over chill has shaped certain First Amendment decisions. It's not that there's a doctrine about chill. It's not that the court's finding a likelihood of chill, but instead the Supreme Court, in shaping the law, is concerned about chill. I think the most important of these, one of the most difficult issues that's going to arise with regard to the First Amendment in the years ahead, is the protection of false political speech under the Constitution. One could make a strong argument that false speech is inimical to what the First Amendment is about. After all, false speech can do real harms. Think of it in the context of an election, how false political speech could actually determine the results. But in 1964, in New York Times versus Sullivan, the Supreme Court said that there has to be protection of false speech so that the breathing space that freedom of speech needs in order to thrive. In other words, the court was concerned that liability would chill speech unless there was protection of false speech. And the Supreme Court thus made it very difficult for public officials and public figures to sue for defamation, even when the speech is false. The Supreme Court followed this a decade ago in United States versus Alvarez. That involved a federal statute, the Stolen Valor Act, that made it a crime for a person to falsely claim to have received a military honor or decoration. The Supreme Court, 6-3, declared it unconstitutional. Justice Kennedy wrote the plurality opinion. He relied on New York Times versus Sullivan. He quoted the words that in order for free speech to thrive, there has to be the breathing space that comes even from protecting false speech. Why is false speech protected? Because liability would chill speech in a way that's undesirable. So this is a sense, I hope you get it, from this description, that claims about chill are pervasive throughout First Amendment law, though the court is often consistent about it. This then leads to the second point that I wanted to make, that normatively, chill should be of great concern with regard to the First Amendment. Let me contrast the First Amendment to all of the other areas of constitutional law. In no other area of constitutional law has the Supreme Court recognized chill as either sufficient for justiciability or sufficient for the constitutional violation. And an example here that I want to give is a case that you might remember from the fall of 2021. What it involved was a Texas law, SB 8, that created civil liability for doctors who performed abortions after the 6th week of pregnancy. At the time the Supreme Court decided this, in the fall of 2021, Roe versus Wade was still the law. States could not prohibit abortion prior to the moment of viability, time when the fetus could survive outside the womb, and that was estimated to be 22nd, 23rd week of pregnancy. Texas prohibiting abortion after the 6th week of pregnancy was flat out inconsistent with Roe versus Wade. Texas, though, did not have its law enforced by state prosecutions. The state played no role in enforcing SB 8. Instead, what Texas did was authorize civil suits against doctors and others who performed abortion. The claim was brought to the Supreme Court that this should be deemed unconstitutional because it would chill doctors, health professionals, from performing abortions that are constitutionally protected. The Supreme Court, in a 5-4 decision, dismissed the case and said it could not go forward against the state of Texas. Justice Gorsuch wrote the opinion for the court. Chief Justice Roberts joined the 3 liberal justices in dissent. And Justice Gorsuch said, claims of chill are not cognizable. And he listed the First Amendment, the Second Amendment, due process, equal protection, and the like. Well, he was right about all of the other areas, being ones where courts don't recognize claims of chill, but not with regard to the First Amendment. Chill is unique with regard to claims of freedom of speech. In fact, you don't even find it in the other areas of the First Amendment, like free exercise of religion or the Establishment Clause. And then it's worth thinking about, why do we recognize chill with regard to First Amendment freedom of speech, but no other constitutional rights? And I believe that's because the Supreme Court recognizes a public benefit to more speech that it doesn't recognize in the same way with regard to other constitutional rights. Of course, there's an individual right to speak, and there is the benefit in terms of personal autonomy to be able to express oneself. But I think the First Amendment is based also on the notion that more speech has a social benefit. When speech is chilled, there's the loss of that social benefit. There isn't an assumption that more guns in society is necessarily a social benefit. There isn't an assumption that more abortions in society is necessarily a social benefit. But there is an expressly stated premise with regard to the First Amendment that more speech is better for society. This is found in many different First Amendment cases and First Amendment doctrines. As an example, when the Supreme Court said that speech by corporations is safeguarded by the First Amendment, it did so not by saying that corporations have an autonomy interest in their expression. Instead, it said that when corporations speak, there's more speech in society, and that's inherently desirable. That's what the court said in First National Bank of Boston versus Bellotti in 1978. To phrase it another way, the court said that corporations have First Amendment speech rights, not because of some intrinsic benefit for corporations, but instrumentally, more speech in society is a good thing. When the court applied this in Citizens United versus Federal Election Commission, holding that corporations have the right to spend unlimited amounts of money in election campaigns from the corporate treasuries, the court invoked exactly this rationale. More speech is inherently a good thing for society. Or another example of this is the Supreme Court cases that have said that there's a right to receive information protected under the First Amendment. In Island Tree's Board of Education versus PICA, the Supreme Court considered whether it violates the First Amendment for a public school to remove certain books from its library. Justice William Brennan, in his plurality opinion, stressed that under the First Amendment, there's not simply a right to speak, but there's also a right to receive information. Well, we can only receive information if it's expressed. And this all fits the notion that there is a benefit to society when there's speech. And of course, when speech is chilled, then not just the speaker who's losing something, but all in society are losing it as well. There are many theories that try to explain why freedom of speech is a fundamental right. Many of them are based on this notion that more speech is a public benefit. So for example, one of the theories as to why speech is a fundamental right focuses on the marketplace of ideas. This was coined by John Stuart Mill. It was articulated by Justice Olive Wendell Holmes in United States versus Abrams. And the idea is that the best way in which a society can achieve truth and find enlightenment is to have all ideas expressed. And the hope is that the false ones will get refuted and the true ones will survive. I'm skeptical about the marketplace of ideas for many reasons. But I also believe the alternative is letting the government determine what's true and censor that which the government deems to be false. And in that sense, I think freedom of speech is based on the faith we're much better off letting all ideas be expressed than we are to let the government pick and choose which ones are true and which ones are false. If you accept the marketplace of ideas metaphor, then more ideas being expressed is inherently a good thing. Chilling speech then becomes undesirable. It's often said that the very core of the First Amendment is to protect political speech, expression related to democracy. Here too, it's not simply the benefit to the speaker, but rather it's that the listeners, that all of society benefit when more is being expressed. And when speech is chilled, then there is a social harm. And so for these reasons, we would say that chill properly is an important consideration with regard to the First Amendment, that the law should facilitate having courts be able to hear claims of chill, finding sufficient standing rightness, and find First Amendment violations. This then leads to the third part of my remarks, and that's how to change the law with regard to chill to accomplish these goals. What I want to begin here is by saying that I think the Supreme Court has been far too reluctant to allow facial challenges to laws on the grounds that they chill speech. For those who've taken constitutional law, the distinction between a facial challenge to a law, declaring it unconstitutional, and an as-applied challenge, saying it's unconstitutional applied in a particular instance, is familiar. The Supreme Court, throughout constitutional law, has been very reluctant to find laws facially unconstitutional. And we would suggest that with regard to freedom of speech, this is inconsistent with what I just said. Why claims of chill should be sufficient? Why facial challenges should be much more readily accepted by the court. The Supreme Court last discussed the standard with regard to facial challenge to the First Amendment July 1st, 2024, in a case called Moody versus Net Choice, and a corresponding case, Net Choice versus Abbott. This involved laws that were adopted in Florida and in Texas, preventing large social media companies from engaging in content moderation. Now, I would posit we all want social media companies to engage in content moderation. Facebook says it takes down 5,000 hateful messages an hour. Social media companies are regularly taking down child sexual exploitation material, even protected by the First Amendment. They're taking down material that might aid terrorism. But the Florida and the Texas legislatures were concerned that they believed that social media companies were disproportionately taking down conservative speech over liberal speech, so they prevented large social media companies from engaging in any content moderation and required that they justify each content moderation decision. The federal district courts in both Florida and Texas declared unconstitutional these statutes. The 11th Circuit affirmed the district court and declared the statute unconstitutional. The 5th Circuit reversed the district court and said it would uphold the statute. And it all came to the Supreme Court. The Supreme Court didn't decide whether these laws were constitutional. The court remanded the cases back to the 11th and 5th Circuits, respectively. Justice Kagan wrote the majority opinion. She said, this comes to us as facial challenges to the Florida and Texas statutes. She said, when a court is undertaking facial analysis under the First Amendment, it has to compare all of the constitutional application of the law to all of the unconstitutional application of the law, and the law is facially unconstitutional only if all the unconstitutional applications outweigh all of the constitutional applications. She said neither the 11th Circuit nor the 5th Circuit undertook this analysis, so we'll send the case back to them. I want to suggest to you that this approach makes no sense in deciding whether a law is facially unconstitutional. How is any judge going to know or be able to dream up all of the constitutional and all of the unconstitutional application of the law? It's asking for an exercise of imagination that's unrealistic. But even if the judge somehow could make a list of all the unconstitutional and all the constitutional applications, why should we say the law is unconstitutional only if the unconstitutional list is longer than the constitutional list? If a law is likely to chill substantial speech or be unconstitutional in a significant number of instances, why shouldn't that be enough even if the list of constitutional applications is longer? Justice Kagan gave two reasons why she thought facial invalidation should be avoided. One, she said, is that inevitably this requires speculation on the part of the court. That's right. Whenever there's a claim of chill, you're speculating about the speech that didn't happen. But isn't her approach also asking courts to speculate and trying to dream up all the constitutional and all the unconstitutional applications and then decide which list is longer? And second, she said, when courts declare laws unconstitutional, they're usurping the democratic process. That, though, is true of all judicial review. Whenever a court is declaring unconstitutional an action of a legislature, it's undermining the political process in the sense it's invalidating what the elected representatives wanted to do. That's not an argument against facial invalidation of the First Amendment. It's really about, do we want to have constitutional judicial review? Justice Thomas wrote a concurring opinion which he said, courts should not declare laws facially unconstitutional because it would violate Article 3 of the Constitution to do so. Justice Thomas said, Article 3 allows federal courts to decide, quote, only cases and controversies. He said, federal courts, therefore, can give relief only to the named plaintiffs, not to anybody else. This is an argument from definition, and it's an unjustified definition. There is a case before the Supreme Court, Net Choice versus Moody, Net Choice versus Abbott. The fact that the court is providing relief that affects other than the plaintiff doesn't violate Article 3. Article 3 requires it to be a case in controversy. There's nothing in Article 3 that says that a federal court's relief can only benefit the named plaintiffs. The reality is, court decisions often benefit beyond the named plaintiffs. So we believe that laws should be facially unconstitutional in the First Amendment if they impermissibly regulate a significant amount of speech. And so we developed this as a three-part approach with regard to chilling of speech and facial invalidity. And we know that judges and lawyers love three-part tests, and so we fit within that framework. First is the question of standing. Does the individual allege that his or her speech has been or is likely to be chilled? We say that's all that should be required. That if a plaintiff in the complaint plausibly alleges that his or her speech has been chilled, that should be sufficient for standing and rightness grounds. Second is the claim with regard to the merits. If a court believes that a reasonable person's speech would be chilled, and the court finds that a substantial amount of speech is likely to be chilled, then the court should find that it infringes the First Amendment. And third, then the burden shifts to the government to meet the requisite level of scrutiny. One of the failures of the Supreme Court to recognize the problems with regard to applying chill is there's always two inquiries in constitutional law. Is there an infringement of the right, and is the government's action sufficiently justified? The Supreme Court has always assumed that finding an infringement with regard to overbreath or chill means the law is unconstitutional. But that omits a crucial step in constitutional law, which is usually the application of the level of scrutiny. So even if the law would chill a substantial amount of speech, still the government would have the opportunity to show that the law meets the requisite level of scrutiny. If it's a content-based restriction, the government, under well-established principles, is going to have to meet strict scrutiny. If it's a content-neutral regulation that affects speech, the government would have to meet intermediate scrutiny. And so, first the court should see, is there a plausible allegation that the person's speech is being chilled? Second, would a reasonable person's speech be chilled, and it's likely that a substantial amount of speech would be chilled? And then third, the government action should be unconstitutional, and thus the government meets the requisite level of scrutiny. And we think that this framework provides an approach to chill that would be much better than the court's ad hoc approach. It would hopefully avoid some of the inconsistency. We then suggest that concerns about chill should influence Supreme Court First Amendment decisions, even beyond this three-part test. And we give some examples in the paper. One is a Supreme Court case, Younger versus Harris, from 1971. If you studied federal courts, it's a case that's familiar. It involved a California statute, the Criminal Syndicalism Act, that made it a crime to advocate the overthrow of the United States government or industrial organization by force or violence. By the time the Supreme Court had Younger versus Harris for it in 1971, it had already declared unconstitutional an identical Ohio law in Brandenburg versus Ohio in 1969. So there was no doubt that by this point, the California law is unconstitutional. David Harris was the head of a socialist party in California, and he got prosecuted in California state court under the unconstitutional California criminal syndicalism law. He went to federal district court for an injunction to halt the state proceedings. He said to allow the state court to go forward against him would violate his First Amendment rights. 4 other plaintiffs intervened in the lawsuit and said that so long as the California law was on the books, their speech would be chilled. The Supreme Court in Younger versus Harris ruled that the federal court had to abstain, that it couldn't enjoin the pending state court criminal prosecution. Justice Hugo Black wrote for the court. He spoke of, quote, our federalism, capital O, capital F, and why federal courts should not interfere with pending state court proceedings. But never did the Supreme Court speak of the 4 individuals who had intervened in the lawsuit. There was no case pending against them. The concerns of our federalism didn't apply in that instance. They were saying that so long as the California law was on the books, a law was already clearly unconstitutional, their speech would be chilled. Instead, Justice Black, in his majority opinion, without referring to these plaintiffs, said claims of chill are insufficient under the Constitution in order to have a violation. Or another example where the Supreme Court didn't speak of chill and should have was a 2006 decision, Garcetti versus Sabalas. Richard Sabalas was, may still be, a district attorney in Los Angeles County. He believed that a witness in one of his cases, the deputy sheriff, was lying. He did an investigation. He wrote a memo to the file saying the deputy sheriff was lying. His supervisor, who was actually a former student of mine at the University of Southern California, told him to tone down his memo. He didn't do so, and he then got disciplined. He was removed from his supervisory position. He was transferred to a much less desirable position. He sued and said that this violated his First Amendment rights. The United States Court of Appeals for the Ninth Circuit ruled in favor of Wallace, but the Supreme Court, in a 5-4 decision, reversed. Justice Kennedy wrote for the court and said, "There is no First Amendment protection for the speech of government employees on the job in the scope of their duties." Think of all of the speech of government employees that's chilled, knowing that there's no First Amendment protection. I did a study of the Los Angeles Police Department 25 years ago after the Rampart scandal, and I heard from so many police officers how afraid they were to come forward and report wrongdoing in their department because they knew that they had no protections under the law. Or think of it again in the context of university professors who are claiming that their speech is chilled. If Garcetti versus Wallace is the law, there's no First Amendment protection. Indeed, the attorney generals of both Florida and Indiana in the last year have argued that when there are laws that restrict speech of university professors, they cannot bring a First Amendment claim because Garcetti versus Wallace says there's no First Amendment protection for government employees on the job in the scope of their duties. Think of the speech that's lost. Think of the speech that's chilled. And yet nowhere in Justice Kennedy's opinion does he acknowledge the importance of chill with regard to formulating this rule. And so ultimately the purpose of our paper was to try to show how pervasive chill is, considerations, standing and rightness as well as speech, how pervasive considerations of chill should be with regard to the First Amendment, and try to offer a much better approach for courts to use in dealing with claims of chill. Thank you.
I'm so honored to be here today and to have the opportunity to participate in this lecture series with Dean Chemerinsky, and especially to honor, can everyone hear me? Okay, there, we'll do it a little bit closer. To honor Judge Wallace's illustrious more than 5-decade judicial career, and to have a chance to speak in this lecture series that focuses us all a little bit on the rule of law, which I think is under unprecedented threat today. And I think Dean Chemerinsky has done an incredible job of making the case for us about why we ought to take chill more seriously and why we ought to think about how we could arrange our constitutional doctrines, our standing doctrine, our free speech doctrine to take a better account of that chill. Typically, we think of chill as something that happens incidentally, right? The government is pursuing a course of action that's targeting unprotected speech or is otherwise pursuing a legitimate goal, but in the course of that, incidentally deters somebody's speech. And as Dean Chemerinsky has demonstrated, that kind of incidental chilling of speech has a lot of negative effects because it limits the amount of discussion that we have happening in our society. I'd like to focus our attention for just a few minutes, though, on current administrative actions where the chill seems to be the point. It's not happening just incidental to the legitimate pursuit of other activities or other goals. It's really the goal itself. And I want to talk about it in the context of something that's very related to freedom of speech and overlaps a lot, and that's freedom of the press. So obviously, there is a lot of overlap between freedom of the speech and freedom of the press, and a lot of the law of freedom of the press is actually quite underdeveloped, and so we often don't think about it or call it out specifically. And I think sometimes when we don't treat it specifically and differently, then we lose our ability to think about, well, what is actually lost when we chill press speech in particular? So I just want to talk about that for a few minutes and to talk about some of the press functions that are really critical to the rule of law that might be being chilled right now. So first, the press serves an important watchdog function. It provides information that allows voters to hold government accountable. Justice Stewart describes this role of the press as organized, expert scrutiny of government. Second, the press works as an educator, a provider of public information about the way that the world works. The press does this in a variety of ways, by investigating and reporting facts, by checking facts that are asserted by others, by framing current events in terms of their historical lens, by providing additional context, and by offering information about the impact of government decision-making. Third, the press functions as a proxy or surrogate for the people. They are our eyes and ears, our boots on the ground, in places we wouldn't have the time or resources or access to go. So taken together, these three functions protect democracy, they promote democracy and the rule of law by ensuring citizens have the information they need to make decisions and to hold their government accountable. Unfortunately, the current administration is actively trying to chill these key press functions. And these efforts are particularly concerning right now because many media outlets today are particularly susceptible to being chilled. Sort of underlines why it's so important to be thinking about that. One reason so many media outlets are particularly susceptible to being chilled right now is because of the collapse of their traditional business models, which means they really don't have the resources. Even legacy media don't often have the resources to defend libel suits or to bring lawsuits to ensure access. Additionally, many media outlets are now part of larger commercial conglomerates, which means they are often part of organizations that have competing business interests, like desire for FCC merger approval, for instance, that make them particularly reluctant or at least a little nervous when they're writing reporting that is critical of the administration. The fact that the current press is so susceptible to chill is a really serious problem because the current administration is actively threatening the freedom of the press. And I just want to discuss 3 ways that it's doing that, and for each just briefly some possible ways that the law might respond. So the first is the threat of lawsuits that are being brought by President Trump himself. In recent months, we've seen the settlement of 2 major lawsuits that President Trump brought. So Disney, the parent company of ABC News, in December paid $15 million to Trump's Presidential Museum and Foundation to settle a libel lawsuit against ABC. Meta, which owns Facebook and Instagram, and Mark Zuckerberg recently paid $25 million to settle Trump's claim that they violated his free speech rights when they suspended his social media accounts in the aftermath of January 6th. Paramount Global, which is the parent corporation of CBS News, is reportedly in settlement talks with President Trump about a $20 billion lawsuit that he brought against CBS for a 60 minutes interview with Kamala Harris. And Paramount has a proposed merger with Skydance Media that needs approval from the FCC to proceed. So these lawsuits risk substantially chilling future media reporting, and indeed that seems to be part of the point. So what kind of legal changes would help address this chill? Well, Dean Chemerinsky was talking about what's the standard for libel, right? Which is something that we should be thinking about. Perhaps we should also consider whether there should be an absolute bar on the president bringing libel or other actions, lawsuits against media, and maybe other people as well. There's an imbalance, right, that happens because we recognize that the president himself has sweeping absolute immunity in both the civil and criminal setting. And he also has the best access of anyone in the world to means to rebut any falsities in media reporting. Perhaps he could use that bully pulpit to respond to any falsities in media reporting rather than using libel law to bully media outlets. An absolute bar would also prevent the president from chilling media reporting by imposing significant litigation costs on media companies. Media incur these costs even when the suit is clearly winnable, and even when, as Harvard professor Noah Feldman said about the 60 Minutes case, the case is so ill-grounded that it comes close to being sanctionable as frivolous. So there are 2 possible ways that we could go about creating this protection for media against these kind of chilling lawsuits by the president. The federal courts could consider doing that as a matter of constitutional law, or state courts or legislatures could also potentially impose that bar as a matter of state law. A second major source of chilling, a threat to press freedom, is President Trump's long campaign to construct the press as an enemy of the people. That rhetoric makes the press more vulnerable to other attacks, including physical attacks on journalists, which have been increasing. Moreover, as a co-author and I argued in a 2017 paper, a president who successfully labels and constructs the press as an enemy of the people leaves the administration more capable of delegitimizing other institutions and constructing other enemies, including the judiciary, the intelligence community, immigrants, and members of certain races or religions, because the viability and traction of counter-narrative is so greatly diminished. This kind of chilling of the press is unfortunately harder to counteract through the law, but it's something we nonetheless should all be keeping our eyes on because it's an important part of the efforts to undermine the press's functions. Courts should also be extremely wary of any attempts to leverage this kind of enemy rhetoric into justifications for invoking wartime or emergency kind of exceptions to normal constitutional and statutory principles. A third threat to press freedom are actions that the Trump administration is taking to limit press access based on the media outlets' past coverage of the president or retaliation for coverage the president doesn't like. And these attempts really undermine the press's proxy functions in particular. Well, what do I mean by that? Let's look at the example of the Trump administration's retaliatory ejection of AP from the press pool for the Oval Office because it refused to change its style guide from Gulf of America to, say, Gulf of Mexico. So how might the law respond to this kind of threat? In some ways, our legal system is really good at responding to these kind of direct attacks on the press. And in fact, just a few days ago, the U.S. District Court for the District of Columbia, based on careful fact-finding, held that the administration had excluded the AP from the press pool based on an impermissible viewpoint discrimination and in retaliation for the way that they were reporting. And that decision was pretty clearly correct, as the president and other administration officials had made perfectly clear that the only basis for the AP's exclusion was that the president didn't like AP's reporting and style guide and its defiance of the president's insistence that everyone refer to the Gulf of America as the Gulf, or to the Gulf of Mexico as the Gulf of America. So the harder questions, though, are really what happens next. The district court, at both the beginning and the end of its opinion, emphasized what it did not hold. It did not hold that AP always has to be part of that press pool. It did not hold that the president has any obligation to be non-discriminatory in the way that it talks to reporters or whose questions the administration chooses to answer, and so on. The nature of the press pool is such that only some press members will be allowed to participate. The constraints of space and access dictate that as a practical matter. The press members that are present then are acting in that important proxy capacity. Traditionally, press members have been selected by the White House Correspondents Association, but recently President Trump has asserted his power to make those determinations. What if next week the administration announces a neutral principle that allows them to exclude the AP and thus to revoke AP's access in the face of the district court's preliminary injunction? What if, for example, they say that only new media that have come into creation, or that have been created in the last decade or so, are eligible for the press pool? Or that the president only likes winner newspaper organizations that are currently gaining an influence and AP's influence is waning, maybe in part because of the restrictions that have been on them in the last couple of months. Is that constitutionally permissible, or should that be treated as pretext, an attempt to launder an impermissible, unconstitutional motive into a constitutional viewpoint and content-neutral rule? This question is incredibly important, and it's also fraught, particularly in the face of a number of recent Supreme Court decisions that exhibit a reluctance to closely scrutinize the president's motives, a tendency to give the president the benefit of the doubt, we might call it a presumption of regularity or a presumption of trustworthiness, even in the face of a clear pattern of discriminatory actions or statements. The clearest example of this that I can think of was Trump versus Hawaii, when despite numerous statements by the president that he intended to impose a travel ban on Muslims, the court held that the travel ban did not unconstitutionally discriminate on the basis of religion. While the court invoked a kind of national security aspect of this case to help justify its approach to examining or not examining presidential motive, the court might extend this approach beyond the national security context. Moreover, national security is a very elastic concept, especially for a president who is already comfortable labeling press outlets as enemies of the state. An order excluding AP could potentially be phrased in purportedly neutral national security terms. Beyond the immediate AP situation, there are significant questions around access more generally. Can the president use ostensibly neutral factors to create a press pool that consists entirely of right-wing outlets that haven't traditionally performed what we might think of as traditional press functions, like gathering facts and fact-checking? What factors are constitutionally permissible when choosing which reporters to give access to? Any court inquiry into these kind of arrangements will be complicated both by potential court unwillingness to examine the president's underlying motives, even perhaps when he makes statements that suggest that unconstitutional motives are at play, and by the paucity of constitutional law about press freedom in particular. Unfortunately, the law about who qualifies as the press, or more precisely, when someone is performing protected press functions, and the nature of any constitutional protections that exist when the press is acting in a proxy capacity, it's very underdeveloped. Historically, it was pretty obvious who the press was, but now we have a proliferation of potential press speakers, right? We have old media, we have new media, we have lots of occasional public commentators. And this explosion of potential press speakers both complicates the notion of who is the press and makes it all the more important that we consider how to identify those who are performing press functions that get constitutional protections, particularly in cases where access can be provided to only a limited number of media speakers. And this isn't just about press pool access, it's about access to prisons and border facilities and all kinds of other places where press access is necessarily going to be limited to only a few press members who act as proxy for the rest of the press and also for the public as a whole. And our failure to think carefully about these questions will make it all the harder for the press to resist and counter the chilling of these important functions. So I hope my comments have added a little bit of flavor to some of what we've been talking about. And I think it's really interesting to think about how Dean Chemerinsky's framework might apply in other contexts. As I was thinking as he was talking about what kind of rights do we say more is always better? Well, voting might be something where we say more is always better as well, at least if you're authorized to vote, right? If you're a citizen, then more citizen voting is always better. So are there other contexts in which the Supreme Court has been too dismissive of the idea of chill that we should examine? Thank you.
I think under the program I'm supposed to quickly respond, but I agree with everything you just said. Rick, I'm so glad that you talked about what's going on now in the context of chill. I just want to broaden this a little bit. And let me give other examples besides the press. One is the revocation of visas from individuals because of their speech undoubtedly will have a chilling effect. In Bridges versus Wixon in 1945, the Supreme Court said explicitly that the First Amendment protects the speech rights of all in the country, citizen and non-citizen. The Secretary of State, Marco Rubio, the President, Donald Trump, have said visas are being revoked from individuals because of the content of their speech in the disagreement. Think of Mahmoud Khalil, somebody with a green card lawfully in the United States, who has been apprehended for deportation solely because of the content of his speech. For anybody who's here on a visa, anybody who's here on a green card, this has to have a tremendous chilling effect with regard to expression, and its actions clearly violates the First Amendment. Or another example, think of the actions that are taken against law firms because of their zealous advocacy. The principle is clearly established that lawyers should not be punished for their clients or their lawful zealous advocacy. And yet we've seen in a series of executive orders the president saying he's doing this for precisely the reason of their advocacy. The first law firm to be disciplined, Perkins Coie, or I guess Covington Burling was the first because of a lawyer that had worked on a matter. The next was Perkins Coie, and the executive order said the complaint against it was that it at one point had represented Hillary Clinton in the advocacy. When the law firm Paul Weiss was disciplined, part of what was said in the executive order was that it represented plaintiffs in suing the insurrectionists from January 6th. When Wilmer Hale was disciplined, it's because they hired the lawyer Robert Mueller after he finished his service as special counsel. I believe that part of what's going on here is an effort by the Trump administration to chill law firms from bringing challenges to its illegal actions and its unconstitutional actions. None of the 20 most profitable law firms in the country signed the brief in support of Perkins Coie, none of the 20 most profitable law firms have yet to bring a challenge to anything that the Trump administration has done. Doesn't that show a real chilling effect? A third example of the chilling effect, just the first few months of the Trump presidency, is the actions brought against universities. A number of universities have changed their websites, their department structure with regard to diversity, equity, and inclusion. The fact that they're doing so on their own, even though they're violating no law, is an illustration of the chilling effect with regard to speech. Even as to the claim of Title VI violations, it's often because the universities allowed pro-Palestinian speech that is protected by the First Amendment. This creates a tremendous chilling effect on speech. And finally, as an example, though it's not directly tied to speech, there's nothing the government's done that will have a more chilling effect, is the claim by the Trump administration of the ability to illegally take people, dump them in a prison in El Salvador, and then say that no court can provide a remedy. It began with individuals from Venezuela. It now includes somebody who was government admitted wrongly taken to El Salvador. Today, the president said that he sees no reason this can't include citizens as well. All it's going to take is they're apprehending one person like me who's a critic and dumping us in El Salvador, and then think of the chilling effect on all speech. And there's no indication that that isn't what they have in mind. Why is it that they're so aggressively arguing that they're not going to return Abrego Garcia? I think they want to establish the right, take anybody to El Salvador and leave them there. Think of the chilling effect on speech. So you're absolutely right with everything you talked about with the press. I would just put together with these other actions in not yet even 100 days.
I also agree 100%. So apparently we're just going to agree a lot.
But now we have 20 minutes for questions.
So there's a lot of
Oh, there's a microphone coming.
so there's a lot of behavior besides speech that's considered to be socially beneficial, like charitable work or things like that. I'm trying to come up with examples. I'm not aware of the court ever using a doctrine of chill to allow people to say, well, you're chilling other socially beneficial conduct. Why do you think speech seems to be treated, at least especially, obviously I think from your perspective, it's not, they're not applying the chill, they're not applying it consistently, but clearly there is a special solicitude for free speech, but not for other conduct. Should the chill doctrine be expanded to cover a whole range of other socially beneficial conduct?
What we say in our paper is that we're not discussing that here, but it's a really interesting question. But it was something we talked about in writing the paper. Should chill be expanded to other things? I think your example of voting is great, because voting is a beneficial, socially desirable conduct. So should we apply the conduct of chill there? And my instinct is to say yes, but nor have I thought through the contours of what that would be.
Yeah, I would agree with that as well. I think there's definitely other contexts that would be interesting to look at. During COVID, a lot of the work that I did as a disaster law scholar was in conjunction with some voting scholars, and we looked at accommodations that different jurisdictions had made or not made for people who were afraid of getting COVID, who had underlying health conditions. And what we saw was that there was less voting in places that had made fewer accommodations, and also that areas that had made fewer accommodations tended, to put too fine a point on it, to have a predictable geographic pattern that made them look like what we used to call covered jurisdictions under Section 5 of the Voting Rights Act, that they had a history of voter suppression. And I think there were real questions about whether part of what was happening was in fact an intent to chill speech, at least in some areas. So if you looked at what happened in Texas, for example, they made accommodations for people over age 65, but not accommodations for other people that were experiencing that chill and not wanting to go vote. And that kind of lined up with the demographics in the state about who was Republican and who was Democrat. And so I think there's all these interesting questions about voting, which is a really fundamental and important right, and a lot of contexts with voter ID, but also with what happened in COVID, where we see these kind of important questions about how much chill of that really foundational right we're willing to accept.
Maybe we can write an article together on applying the concept of chill to voting.
That
I
would
think
be
your
super
point is a
fun.
great one.
I'd love that.
Do you view, I guess, criminal statutes that intentionally chill, particularly political speech, like the Anti-Riot Act, as different in kind or degree when you're thinking of chill?
I don't think they're different in kind, but I think any law that regulates speech should be analyzed through the framework that we say. Now, it may very well be that when you get to the third step of the inquiry, you say the government can meet strict scrutiny, and so the law is constitutional. But I think that any law, whether it's intentional about restricting speech or unintentional to restrict speech, if there's the plausible claim of chill and likelihood of chill, should be subjected to the same analysis.
I'm curious if you could talk a little more about the substantial amount of speech that you talk about at the second point of your inquiry, and I guess how you envision that, and for example, if that applies to chilling a substantial amount of speech by the parties, by people more broadly, and whether substantial amount refers to a volume of speech or the importance, the underlying importance perceived for the speech.
I think the notion is if there is a likelihood that speech will be chilled, then that should be enough to get to the third step. And I think all we're saying is if it were a de minimis claim with regard to chill, then we would say that wouldn't be enough at the second step. But I don't think we want to create this as a significant threshold. And it really goes to what I was saying with regard to the Supreme Court's decision last year in Moody versus Net Choice. Why should it matter whether the unconstitutional applications are longer than constitutional applications? If there is a significant loss of speech, that should be sufficient. But I think we'd want a standard that tries to avoid that line drawing as much as we can. There's someone in the front who had a question. And this is Jenny Boyd, who's our terrific director of events at the law school.
Hi, yeah. You've talked about, in your article, about laws that are enacted to restrict freedom of speech. But in the last part of your talk, you talked about some of the current events that have been happening with Kyle and other
Sure.
students who have written articles, and you've talked about the press and so on, where there may or may not be specific laws that regulate speech that are being applied to them. It feels though that just there's a general chilling atmosphere that has been created by this administration against freedom of speech in the context of universities and the press. And I'm just wondering any suggestions that you have about this general atmosphere where there may not be specific laws that have been enacted that you can apply, your three-part test or, that can be done to try to bring this issue of the chilling effect of the government's actions on everybody right now.
It's important to recognize that the First Amendment applies to all government actions, whether they be laws or executive actions, whether they be from the federal government or from state or local governments. I like to say at the beginning of my First Amendment course that the first words of the First Amendment are all untrue. It says, Congress shall make no law. Well, the First Amendment isn't limited to Congress. It includes the president, it includes state and local governments. It's not limited to a law. It would include any executive action as well. And it's certainly not no law, because of course there can be regulations of speech. And it's strange that the amendment that we revere so much begins with words that just are untrue. And so in that sense, when I speak of law, I'm speaking of government action more generally, not just a statute passed by Congress. And so the actions of the administration are certainly covered by the First Amendment. So Bridges versus Wixson that I mentioned involved the San Francisco labor leader, Harry Bridges, and the effort of the federal government to deport him because of his allegedly being a communist. And the Supreme Court said, you can't deport somebody for being a communist based on their views. Even though he's a non-citizen, he's from Australia, it's still somebody protected by the First Amendment. So that illustrates what I was saying. It's not just a law. It's any executive action. And you go through the list of things that to us topic, denying the AP certain privileges. The district court found that that violates the First Amendment, even though it's not a statute in itself. So the First Amendment is broader than just laws.
Can you just as a follow-up, can you anticipate at all what the Supreme Court might do when some of these cases eventually make their way up?
I'm not a First Amendment scholar, so I'm going to defer here. I'm very interested in your answer.
I don't know is the honest answer. And the limited record from the Supreme Court so far is inconsistent. I thought that the Supreme Court would clearly say that the president can't refuse to spend money appropriated by a federal statute, that violates separation of powers and violates the Impoundment Control Act. There have been 2 Supreme Court rulings on impoundment of funds so far. One said that the district court could stop the impoundment. The other said the district court couldn't stop the impoundment. The only justice in the majority in both instances was Amy Coney Barrett, and she did it right. I don't know what to draw from that. Last Monday, the Supreme Court said that with regard to individuals in Venezuela who were taken to El Salvador, they should be bringing habeas corpus petitions when they're held in Texas, not bringing the habeas corpus petition in DC. But it didn't address any of the hard questions. Is there any legal authority to take people to El Salvador? Does the Alien Enemy Act of 1798 apply? Is judicial review available? In the ruling last Thursday from the Roberts Court concerning Abrego Garcia, at first I thought was a victory for Abrego Garcia, saying that the district court can facilitate his return, but the court said we don't know what effectuate means, and now the Trump administration has filed a brief saying we don't have to do anything because we can't tell a foreign country what to do. What's the Supreme Court going to do when it gets there? I don't know what the Supreme Court's going to do in the AP case, which is probably the one that you mentioned soonest to get there. Is the Supreme Court going to follow the district court and say you can't deny the press access on the basis of the tape? And there are cases, the Sherrill case in the DC Circuit in 1977 being an example, but I don't know where the court will go. And what I'm, as I say, most concerned about is, are they really going to say that the government can put people in El Salvador illegally, in error, and no court can provide recourse? I can't believe the Supreme Court will go that far, but we'll see and see soon.
I would still hope that the AP case is pretty straightforward.
I do too.
But, right, that seems like a pretty straightforward application of established, and you can apply forum analysis and other things. So hopefully it is a relatively straightforward case. But I mean, I think there's real questions, and there's a lot of less clear areas, right? So there's reports that the administration is refusing to answer questions from reporters who have their pronouns listed in their email signature, right? And that gets into ground that like everybody in the case was basically conceding, oh, the president can talk to whatever reporter he wants, right? So is that the principle, that there's no limitations on these more kind of informal interactions? Is there any limit there? And I think those are things we don't really know, but yeah, I hope that the court will be firmer next time it tries to. It's hard to know, how much the court is dancing around these issues because they don't want to provoke the full conflict, right, between the courts and the president just saying, oh, we're not gonna do what the court says. And I think there is real nervousness around that, and probably for good reason. But you also can't shirk from the ultimate constitutional duty, right, of saying what the law is. And I can't imagine that the law is anything other than you can't just essentially kidnap people off the street and take them to El Salvador without any process. So.
There's another question.
Sorry for doing this twice, but I actually would like to, since everybody is being kumbaya here, I'm going to try to take another position just to kind of see what the limits are of this, because so I'm a banking lawyer, as some of you know, and one of the big issues the last 5 or 6 years has been something called Operation Choke Point.
choke point 1.0 and 2.0. 1.0 was the bank regulators basically telling the banks, you have reputational risk if you bank sort of disfavored businesses like payday lenders, we don't like them, gun manufacturers, oil and gas companies. And so there was allegations that the banks were shutting down bank accounts, and of course it's pretty hard to do business if you can't have a bank account. That was then discredited as a bad idea, government shouldn't do that. And then most recently, and it's sort of labeled Operation Choke Point 2.0, it is the regulators putting pressure on the banks to say debank cryptocurrency companies because they're bad act. We don't really like those disfavored businesses. Then I want to sort of relate this. So that's sort of the background. So sorry for the long question, but it gets to a case that the Supreme Court decided called NRA, National Rifle Association versus VULO, which you may be familiar with, probably so. And that's interesting because so the Operation Choke Point is usually referred to as fair access cases, and there's a whole bunch of state laws that say you can't deny lawful businesses access to banking or insurance services. And NRA versus VULO started out as a fair access case by saying the New York DFS is threatening to bring actions against insurance companies if they provide insurance to the NRA. And then at the Supreme Court level, they got a really good, clever ACLU lawyer to represent them who converted that into a First Amendment case, which then the NRA won 9-0. And it was I would say it's a chill case. It's a chill. So
Very much.
what is a little, how do you, is there, maybe it's not, maybe you don't think it's a bad thing, but can't clever lawyers turn almost any action into a chill case if they want to? And what is the limits to say we shouldn't be able to turn every case into a chill case?
I'm going to say three things. First, no, you can't turn everything into a chill case. You have to have a plausible allegation that speech is being chilled. Not everything that the government does relates to speech or even can plausibly relate to speech. Second, I know nothing about banking law or Choke Point 2.0, so I can't address that at all. But third, I do know National Rifle Association versus VULO decided last spring by the Supreme Court. A little bit of background, and then I can maybe tie it to your question. Maria VULO was a business commissioner in New York. After the tragic Parkland, Florida school shooting, she went to insurance companies and banks that she regulated and said that they should stop doing business with the National Rifle Association, and if they didn't, that the state had certain sanctions it could impose on them. This, by the way, is all of what the complaint alleged, and the Supreme Court in Justice Sotomayor's opinion said the allegations of the complaint have to be taken as true for purposes of the motion to dismiss. The NRA sued VULO, saying that her actions punished the NRA for the speech that they were engaged in. Now, what's interesting is VULO had no direct contact with the NRA. It wasn't that she was threatening the NRA. She said the insurance companies and banks, if you keep doing business with the NRA, then you'll have problems with the state of New York. And the United States Court of Appeals for the Second Circuit said that there was no First Amendment claim because VULO hadn't done anything. All VULO had done was engage in speech, and speech by government officials is in itself a violation of the First Amendment. Justice Sotomayor wrote the opinion for the court reversing the Second Circuit. You're right, David Cole, then the legal director of the ACLU, represented the National Rifle Association. And Justice Sotomayor relied on a 1963 Supreme Court case, Bantam Books versus Sullivan. It involved a Rhode Island Commission on Morality and Decency that developed a list of books that it found objectionable and said that those who sold those books could face criminal prosecution and liability. And some sheriffs went to local bookstores and said, you're selling some books on this list, you could be arrested and prosecuted. And the Supreme Court, in an opinion by Justice William Brennan, said that that threat, even though there was no actual prosecution, violated the First Amendment. Justice Sotomayor, in her opinion in NRA versus VULO, at the beginning and the end said, this is governed by Bantam Books versus Sullivan. The government made an actual threat, and a threat, when it's credible, can violate the First Amendment. Indeed, we discussed this in our paper as the court's concern about threats is part of an indication where chill comes up. It's very much about chilling speech and advocacy. And I don't think that NRA versus Bula goes any further than Bannon Books versus Sullivan says that if there is a credible threat of prosecution, that threat is enough for a violation of the First Amendment.
Yeah, the reason it's interesting is it started out as a First Amendment.
First
plus
Amendment was there from
others,
the beginning.
But it's interesting because originally, those of us, at least the press here, looked at it as a fair access case. And then the arguments were very cleverly made at the Supreme Court level that really focused on the First
And I think David Cole did a terrific job, but even at the Second Circuit, the focus was on the First Amendment. With the Second Circuit saying this is just speech by a government official, that in itself doesn't violate the First Amendment. And the opinion by Justice Sotomayor said, but there was a threat, and the threat of prosecution, because of the chilling effect on speech, would be enough. Unless there's other questions. Please.
I have one.
Do you want to wait for Jenny to bring the microphone? The last question.
So I'll just give one example of the many threats that President Trump has made. He has threatened Jack Smith, who brought the two big cases that eventually had to be dismissed because of Trump versus United States ruling in the Supreme Court. So that certainly threatens Jack Smith, freedom of speech and livelihood. So will that constitute a case against Trump? Or I guess Trump would be immune.
And I guess the question would be, what relief would Jack Smith seek at this point? I'm not sure. I mean, obviously, if Trump were to take actions against him, the first law firm to get named was Covington and Burling. And the reason that it was named in the executive order was one of the lawyers that assisted Jack Smith.
Right.
So, let me do several things. One is to invite you to a reception that's up in the hall. The second is to very much thank all of the law clerks for Judge Wallace who made this lecture possible, and I want to thank them for inviting me. I want to thank Lisa for coming from Utah to be a commentator and be here. But most of all, I want to thank Judge Wallace for all that he has done for the judiciary and society. Just so incredibly proud that you're a graduate of Berkeley Law. Thank you.